In JXX, a protected party by his litigation friend ABB versus Archibald and another, and HLA, a protected party by her mother and litigation friend HDA versus LXA and others, Senior Costs Judge Rowley determined the correct approach to assessing medical reporting organisation fees on detailed assessment. The court held that such fees are properly characterised as a disbursement, not as outsourced solicitors' profit costs. Consequently, the long-applied Stringer cap, derived from Stringer versus Copley, which required a comparison with the hypothetical cost of a solicitor doing the work, was not the correct legal test. The judge also rejected the defendant's argument that commercial terms involving deferred payment or write-off facilities constituted irrecoverable funding costs under the principle in Hunt versus R.M. Douglas Roofing Limited. However, the court equally rejected the claimant's contention that the aggregate fee was immune from scrutiny, finding the tripartite tension in the market meant competition was an imperfect regulator of reasonableness between the parties. On the evidence, which showed markups typically ranging from 30% to 53%, but calculated on a macro business basis, the judge was not persuaded the full amounts were reasonable. Applying a cautious approach under the rules and the overarching objective, he concluded that a markup of 25% on the expert's fee, including associated disbursements, represented a reasonable and proportionate amount recoverable between the parties. The court therefore ordered that the medical reporting organisation fees be assessed on that basis, with any claimed percentage above 25% reduced accordingly. Quote, "Where there is a limitation to the receiving party's evidence, the court needs to take a cautious approach. I think that is the situation here, and I am not persuaded that even the range of 30% to 53% generally charged can be considered reasonable, let alone the outlier percentages, some of which result from fixed sums having been claimed. The general range of 30% to 53% plainly reflects variations resulting from ongoing commercial relationships between the solicitors and medical reporting organisations, rather than any case-specific factors. There is nothing wrong with those relationships, but they are not any basis on which to allow any particular percentage between the parties. Having spent a considerable time reviewing the evidence and submissions in this case, both as documentation and in this decision, in my judgment, a markup figure of 25% between the parties would be a reasonable percentage. More than that would be a matter for the claimants, their solicitors, or the medical reporting organisations. Any markup claimed of less than 25% would be limited to that percentage.
For a detailed summary of this decision, visit tmclegal.co.uk.